The facts matter.
Good morning, everybody. It's Virgo, and it is January 13th, 2021. I have an awesome Moor fail here. And when I say an awesome Moor fail, I mean it's an awesome fail. These guys really have to work hard at failing this well. And they managed to do it here. I'm going to go through this case with you because I think you'll find it interesting. Plus, I want it on the record. It's an important one. It doesn't only debunk the lies that the Moors tell, but it also debunks something called accepted for value, which is something that the Sovsits like to claim all the time. So I'm going to be going over this case, and I think you guys will find it as hilarious as I have. All right, so what this is the United States Court of Appeals, 7th Circuit, and it is on a case. It has been brought forth to the Court of Appeals by Baba Dainja L, who happened to be the plaintiff in the case. Now, the Americredit Financial Services Incorporated et al. Are the defendants in this case because this man has lost his mind. All right, so before Poshner, Wood, and Tinder circuit judges, Baba Dainja L, Chicago, Illinois, pro se, of course he's representing himself, and David Joseph Franklin Sorman and Frankel Limited, Chicago, Illinois, for defendants, who are standing in front of the Court of Appeals, the judge. So the plaintiff, who is Baba Dainja L, bought a used pickup truck in 2011 for $28,000. And he financed the purchase by means of a 6-year installment contract that specified an outrageous interest rate of 23.9%. Now, keep in mind that I don't have a credit card with that high of an interest rate, okay? So if you can imagine what the interest would be like on $28,000 in an automobile loan, at a 23.9% interest rate, I mean, that is really outrageous. The dealer who sold him the truck assigned the contract to Americredit. But after making the first, and only the first, installment, the plaintiff sent his new creditor a copy of an installment contract that he had stamped, accepted for value, and returned for value for settlement and closure, and told Americredit to collect from the U.S. Treasury the balance due Americredit under the contract. I think you guys can see where this is going, right? Americredit repossessed the truck, sold it, and billed the plaintiff $11,322.28 to cover the difference between the price at which the truck had been resold and the unpaid balance on the installment contract. I'm going to stop here just to kind of put some information in here. Innocently, a lot of kids that grow up and they get their first loan on an automobile, which happens frequently. That's why there's these massive amounts of first-time buyers programs. The kids, for some reason, think, oh, you took the car. I'm not responsible for the remainder of the balance, but that's just not true. When a vehicle sells at auction, it generally sells for about half of the amount of the actual retail value, and even in a brand new truck that had only been used for a month, you're still going to get a very small amount in comparison to what you owe due to all of the interest, especially almost 24% interest. So I'm guessing that this person actually didn't realize that this was going to happen, but here we go. So the plaintiff responds by suing Americredit and 2 of its officers in a federal district court in Illinois for $34 million in compensation damages and $2.2 billion, mind you, in punitive damages. Punitive damages. Needless to say, he was proceeding pro se. The district judge couldn't make sense of the complaint and dismissed it as being frivolous. Frivolous it is. though not completely unintelligible. It has the earmarks of the Sovset movement. As explained by the FBI, Sovsets view the U.S. government as bankrupt and without tangible assets. Therefore, the USG is believed to use citizens to back its U.S. currency. Sovsets believe that the USG operates solely on a credit system, using American citizens as collateral. Sovsets exploit this belief by filing fraudulent financial documents, charging their debt to the Treasury Department. Federal Bureau of Investigation, Sovsets, An Introduction for Law Enforcement, which was written November 2010 and revamped again in 2017 for you guys that don't know. It is a very, very good read if you have not read it. And all you have to do is type that into the search engine and it will come up. They update it every few years. The plaintiff based federal jurisdiction on the admiralty and diversity jurisdictions of the federal courts. Admiralty jurisdiction over his case may seem unavailable to him on two grounds. The case has nothing to do with maritime activities. And for those of you that don't know, admiralty is on the seas. So, basically, he's claiming that the court is a court that you would normally find for maritime issues, for things that happen on the sea. Oh boy. Okay. In the absence of diversity of citizenship, it is essential to jurisdiction that a substantial federal question should be presented. And then it quotes a bunch of case laws to show precedent. The first ground is solid, but not the second. Article 3, Section 2 of the Constitution confers federal jurisdiction over admiralty cases. But cases don't have to arise under federal law in order to be within the admiralty jurisdiction. And then it wants you to take a look at Romero versus International Terminal Operating Company and all of these other cases. They just have to involve maritime activities. Often, however, they do arise from federal law, either statutory or judge-made. It is unclear what the plaintiff's admiralty claim arises from, but clear that the claim is not within the admiralty jurisdiction because it has no relation to a maritime activity. No, it's an automobile that drives around on land. The Sovset movement does not recognize the limitation of the admiralty jurisdiction to maritime activities. Oh, okay. Dismissals because of absence of federal jurisdiction ordinarily are without prejudice. Dismissal for want of federal jurisdiction with prejudice is inappropriate because a dismissal may improperly prevent a litigant from refiling his complaint in another court that does have jurisdiction. Let me explain to you the difference here. A lot of people misunderstand this. So a case that is dismissed with prejudice means that you can go and refile your case once you get your act together. But a case that is filed without prejudice means you can't file that case ever again. And that's what he's speaking of here. And perhaps more essentially, once a court determines its lack of jurisdiction over a claim, it perforce lacks jurisdiction to make any determination of its merits of the underlying claim. Let's see. In rare circumstances, a district court may use its inherent power to dismiss with prejudice as a sanction for misconduct, meaning you can't file this case anywhere ever again. You're acting like a Looney Tune, and if you try, we will eventually get you as a vexatious litigant. Even a case over which it lacks jurisdiction and its decision to do so is reviewed for abuse of discretion. We return to this qualification at the end of the opinion. Second, if the reason there's no federal jurisdiction is the plaintiffs having predicated jurisdiction on a frivolous federal claim, dismissal with prejudice is appropriate. For such a suit will go nowhere in any court. This almost certainly is the case as the plaintiff's admiralty claim is concerned. If that claim is founded on federal law, though if not, it's still outside admiralty jurisdiction, as we've pointed out. But he invoked diversity jurisdiction as well. And if there was diversity jurisdiction, but the claim asserted was frivolous, the case should have been dismissed with prejudice. When a case of which the court has jurisdiction is dismissed because it fails to state a claim which a frivolous suit obviously fails to do so, the dismissal is a merits determination and is therefore with prejudice. The difference between a federal question case that is frivolous and a diversity case that is frivolous is that the latter case, but not the former, is within federal jurisdiction because a substantial claim is not a condition of diversity jurisdiction. Okay, so I'm going to spare you me reading the whole next paragraph because it's basically about the Court of Appeals being irritated that the district court dismissed the entire complaint without prejudice, which they're wishing that they had dismissed it with prejudice so that this guy was not able to actually go to the Court of Appeals with a case that is completely frivolous like this. All right, so the next part is AmeriCredit filed a counterclaim to the amended complaint seeking the $11,322 that it was out plus prejudgment interest and now attorney's fees. It did not seek and could not, for a mere breach of contract, have obtained punitive damages. Let's see. It might have charged the plaintiff with fraud, in which event it could have sought punitive damages, but it did not. So they could have gone after him for fraud because of this whole accepted for value thing. But they didn't. They were just like, you know what? We're just going to go ahead, and this guy's obviously got some issues, so we'll just go ahead and move forward with regular court. So they might have been able to charge, they could have gone ahead and charged him with fraud, but they didn't, which in any event could have brought punitive damages had they want to, but it did not. The plaintiff did not answer the counterclaim, and eventually the judge entered a default judgment for a total of $13,582 plus costs in favor of AmeriCredit. The plaintiff has appealed. The appeal tracks his submission in the district court. In their belief, in response, the defendants argued that the district court never acquired jurisdiction over the plaintiff's suit because the only possible basis for federal jurisdiction was diversity of citizenship, and the complaint didn't state a colorable claim for monetary relief in excess of $75,000 as the diversity statute requires. So that's not a jurisdiction available either because the amount is not the monetary relief that would be needed to warrant that. It's just insane. This guy is all over the place. If there is no jurisdiction over the plaintiff's suit, there would be jurisdiction over the counterclaim only if it were filed as a freestanding suit. It would be within federal jurisdiction. And then it tells you to go through a bunch of case law to find where he found that information. The counterclaim is based exclusively on state law, so the only basis of federal jurisdiction is the diversity jurisdiction, which requires that the parties be of diverse citizenship and the amount in controversy exceeding $75,000. The defendant's brief asks us to affirm the default judgment, but does not contend that the counterclaim satisfied the amount in controversy requirement. The plaintiff's opening and reply briefs don't mention the counterclaim. All right, so just so that you guys know, Moors believe that they can never win in state court. They believe everything has to go through federal court, which virtually makes no sense whatsoever, but that's why they try to get everything that they can in the Court of Appeals. Okay, let me get down here to because all of this is just stuff that really is not. You can go back and read it if you want to. The link will be in the description. But for the purpose of keeping this video a reasonable length for you guys, let's see. Okay, so the bottom line is the case gets dismissed, but this time dismissed without prejudice, so that this way there is no way that he can file the case over again. Now, one of the things that makes this case very interesting and why it's so important that hopefully the Moors hear it is because, number one, the claim to accepted for value or anything that is like an A for V type of presentment is total BS. Not just a little BS, total BS. Because in addition to losing any lawsuits and not getting your item paid for, you're going to end up having that item, chances are, repossessed. Or you're going to, and then in addition to that, you're going to end up with a nice $5,000 fine from the U.S. Treasury for sending in frivolous paperwork, which they do not play with. They give you one warning, and then they fine you $5,000 per sheet of paper that you file with them that is considered frivolous. Accepted for value is another big scam that's part of the SOVSIT movement, and as I've said many, many times in the past, the saddest part about the Moors that have picked up on the SOVSIT scams and are running them all over their channels and Facebook and Instagram and everywhere else is that the SOVSIT movement was founded in a very, very ugly, white supremacist sort of way. I mean, it isn't like a little bit. It is a big deal. These guys really originally started out with this scam, attempting to try to find ways that would fool people of color at the time and get them thrown in jail. And these people have picked it up and ran with it. It's really sad, and I've tried to inform them many, many times. This is just one of hundreds, probably thousands by now, of cases that end this way. Eventually, if you're a person like Eon, for example, Eon's channel would run this scam and would inform everybody of all of this SOVSIT garbage, all the while being a vexatious litigant himself, because he had filed so many bogus pro se documents that now if he ever needs to go to court, he has to have a either a court-appointed attorney, or he has to hire an attorney that's part of the bar that is licensed in order to file even the most simple document in court, in several courts. So it's really, and that's how they deal with it. In the event that you continue to file these bogus documents, what they will do is they will put you on a list of what's called a vexatious litigant, and you will no longer be able to file on your own anywhere within that jurisdiction. So I wanted to just share this with you guys. I find it absolutely hilarious. Hopefully you guys got some enjoyment out of it. If you want to read it for yourself, the link is in the description. And I hope everybody has a great day. Bye-bye.